hands.
Thank you, Your Honour. Ms Glass, I was asking you questions earlier in relation to complaint handling, and you gave evidence that you understood from Mr Geary's evidence that he received complaints and referred them to the department. That's right?
Yes.
And that you thought those complaints, or had an expectation that those complaints should come to you, is that right?
I certainly expect a fair number of those complaints to be referred to my office, yes.
By Mr Geary or by the department?
By Mr Geary.
And you hadn't received complaints by him or via the department?
I wouldn't expect to receive them from the department. I would get complaints about the department.
Thank you. Now, Mr Kinman, back to you. You were giving evidence in relation to the findings that you had made, and you indicated that in relation to a complaint which would amount to a criminal offence, sexual conduct, sexual misconduct or sexual offence, in order to sustain it, there'd need to be a conviction against the perpetrator.
In the vast majority of cases, if one had an admission and for some reason, for example, if a child is abused and the child is so traumatised that the parent insists, or a professional may give advice that even the court process itself would be too traumatic, then in those circumstances that would be a rare case where if you had a clear admission and for a reason of that type the matter did not proceed to trial, that might be an exceptional case where I formed the view that one was entitled to conclude sexual offence. Sexual misconduct, though, is much broader, and that's conduct that involves an inappropriate and overly personal or intimate conduct towards, relationship with, or focus on a individual child or a group of children.
It wouldn't amount to grooming, or would amount to grooming?
Well, the difficulty, of course, with grooming, and that's I shouldn't say it's a good question, but it's a very important question, because early on we used the grooming label as the primary source of primary advice as to sexual misconduct matters that needed to be notified. The difficulty with grooming is, of course, one has to demonstrate that grooming, implicit in the notion of grooming, is grooming for a purpose.
Intent.
It's precursor to a sexual assault. And so that was highly problematic because often with these matters, very early on in the investigation, one can show that the individual's engaging in inappropriate or overly personal conduct towards a child, relationship with a child, but you can't get firm evidence to demonstrate that what the motive behind that conduct is. And so early on, when I took over responsibility in this area, I redefined sexual misconduct along the lines that I've just outlined. That has very significant implications, because the investigator, of course, will continue to chase lines of inquiry until such a time that they think either that the matter is going to be proven or that there's no point in continuing to chase rabbits down burrows. Now, if you have a requirement that you need to prove that somebody intended to form a sexual relationship with a child, then you're not going to chase many of these matters very far, notwithstanding disturbing behaviour, because you know you're not going to be able to prove it.
What about sexual exploitation? How do you deal with that?
Well, depending the context, you would argue that depending on a particular behaviour, it could involve conduct towards or relationship with a child. So you look at it through that lens. It would depend on the nature of the behaviour.
If the allegation is of child sexual abuse amounting to a criminal offence, that is notified to you, does that mean that automatically it goes to the Joint Investigative Response Team and is dealt with as a criminal matter?
In the main, but we have had matters where that hasn't been the case, and so we've ensured that that's been remedied. Let me also say...
Well, just let me stop you there. So either by some other mechanism it goes to JERT, perhaps through fax, or because of your intervention it goes to JERT.
That's right.
But any matter that's reported to you that amounts to, for our purposes, indecent assault or sexual assault would find its way very quickly to the police.
Ought to find its way to the police, but we, of course, are on the record of demonstrating via a number of investigations that there's been a failure to refer matters to the police, and unfortunately, that failure on a number of occasions has been on the part of the Statutory Child Protection Authority, failing to ensure the referral of matters.
Do you consider that it's your obligation as the receiver of notifications when the allegation amounts to a criminal offence to tell the police?
It's absolutely our obligation to make sure that the police are advised and that they're advised promptly. If that then requires us to notify the police, then we'll notify the police. On occasions, we will simply indicate to the agency, because it's got the holdings, well, they might have the full holdings for them to make contact. But we will always follow these matters up. Now, it would be fair to say that practice of some years ago tended to be a more hands-off approach by my office. And quite frankly, that's unacceptable. My mantra to my staff is risk times time equals tragedy. And so if we have information that indicates that a child's at risk or an investigation is at risk, and we don't satisfy ourselves that the matter has been moved forward quickly and the relevant information has been provided, if we don't ensure that, then we are failing in our responsibilities.
Assuming then that the allegation is of a criminal nature, child sexual abuse in our language, assault or indecent assault in criminal language, occurs, it must be made to your agency, that's right?
That's correct.
And your agency would ensure, one way or another, that it got to the police. In those circumstances, you wouldn't investigate it, would you?
No, we wouldn't, but let me give a variation on that theme.
Just before you vary it, you wouldn't investigate it?
We would conduct certain inquiries. So it is routine in those matters that we'll look at the police system and have a look at where the matter is at.
But it wouldn't come to a finding of sustained, not sustained.
Oh, we wouldn't complete an investigation, but we may do some inquiries on the basis of information that we've got that perhaps the police don't have.
That's all right. But in terms of your outcomes and findings that you've given evidence of earlier this morning, no matter where it's an allegation of a criminal assault that's gone to the police will find its way into the findings that you've told us about?
No, that will include the matters where the police have laid charges.
So the sustained is in relation to an outcome of the police, that is, a person's been charged and ultimately convicted.
If, for example, that's a criminal matter. If, on the other hand, it's sexual misconduct.
No. Let's just limit ourselves to criminal matters. Right. We need to understand the pathway where a criminal complaint is made in out-of-home care. So your evidence so far is it must come to you, and you will tell the police if no one else does, and you'll make sure that someone tells the police if it's not you. If the police then, following their investigation, charges a person and there's a conviction, it will be a sustained finding in your findings.
That's correct.
That's right. If the police do not charge a person, is the finding that you come to based on your own criteria, regardless of the police action?
The finding that we will very carefully consider is whether there should be sexual misconduct finding.
That is a lesser offence.
A lesser offence. And what we need to find then is that there was some conduct of an inappropriate nature which doesn't go to the heart of what was needed to prove the offence, but which clearly shows somebody who behaved in an inappropriate way with the police. Just one other point I might make too is, and this is important, that historical allegations, so matters that are made by people as adults that indicate that they were abused as children, of course, find their way, a certain significant number of those matters find their way into our scheme. For historical allegations, they're not matters that are dealt with by JIRT. They're matters that are dealt with at the local area command. Mm-hmm. And quite often with historical matters, one might go back a number of years in terms of relevant holdings, and one might be in a position to suggest to police, based on our review of both the child protection system and of the police system, that there are certain lines of inquiry that they can pursue. Let me say, I cannot think of one case where we've taken it up with the police, put suggestions, and they haven't pursued it, and they haven't done so willingly. So it's a good cooperative system that's in place.
Thank you. Now, you, as part of your keeping under scrutiny, for our purposes, the out-of-home care system, you recently worked in the Aboriginal out-of-home care sector. Can you tell us about the work you did there? Yes.
This is a combination of using our data.
Can you tell us about the work you did there?
Yes. So we conducted an analysis of reportable conduct matters coming from the Aboriginal out-of-home care sector, and we noted that the reporting rate was lower than one would expect. We then entered into discussions with ABSEC, individual Aboriginal agencies, with the Children's Guardian and with FACTS. And so there's the consultation process. One doesn't jump to conclusions. The important aspect of the consultation process too is about building consensus and assuring people that our focus is on system improvement rather than going on a fault-finding expedition. In addition, and this is something that came as a result of the request from the Aboriginal agencies themselves, we conducted a significant amount of training activity to individual Aboriginal services. And as a part of that training, we used our connections with New South Wales Police to bring senior people from local area commands where the Aboriginal organisations were working to have a session with the Aboriginal providers as to the respective role that, and relationship they could have with the police in relation to particularly difficult matters that agencies needed to deal with. For example, matters involving criminal behaviour. The good thing about the relationship too was Aboriginal out-of-home care services are also interested in their community. And so that then allowed a very good discussion between police and those organisations around broader child protection issues that are in play within Aboriginal communities. It occurred to me, though, that with these one-off training sessions, I might well be retired before I finish the exercise. So we needed to accelerate the process. I'm not about to retire. And so what we thought we'd do is put on a fairly major forum, and we had over 150 attendees. ABSEC absolutely backed it, which was fantastic. And all of the Aboriginal organisations were represented. We had senior representation from the Child Abuse Squad, and we had senior representation from the police. A number of assistant commissioners attended. And the Aboriginal sponsor for the police, Jeff McKechnie, attended and was very supportive. We were particularly interested too in having all of the commands represented where the Aboriginal organisations were located. And so there was some general training that took place, but our major focus was relationship building, and not just relationship building for the sake of it, but relationship building that was targeted on the Aboriginal agencies in particular locations and the local area commanders having a focused discussion on what they needed to do moving forward, so that the interface between Aboriginal organisations and police was a solid one, so that whether it's a reportable conduct matter arose, or it might be a serious client-on-client abuse matter arose, or alternatively concerns about sexual abuse within an Aboriginal community more broadly, the relationship existed and the Aboriginal organisation was able to work with the police.
What's the outcome been of that, Mr. Kinman?
The outcome in terms of reportable conduct matters is we received 71 reportable conduct matters from the Aboriginal out-of-home care sector for this financial year as of the 25th of May, 71, which is more than a threefold increase in the number of reportable conduct matters.
And you put that down, at least in part, to the work you did in that community.
To the range of activities. The other thing which I'm very keen to see unfold, and I'm on the Police Aboriginal Strategic Advisory Council, is the police have a performance management framework in place. And Assistant Commissioner Jeff McKechnie is very keen to see that the forum was not just a talk fest, and that he will hold commanders to account in terms of them demonstrating concrete action by way of ongoing relationship building with those Aboriginal organisations. And so that will be monitored through the police performance framework.
Thank you. Mr. Clark, have you done any work in the Aboriginal community in relation to out-of-home care?
No.
Is that something that's on your future agenda?
If it related to my normal function as Ombudsman, or indeed, as I alluded to earlier, the additional priority of looking at complaints, I think it falls more reasonably under the Queensland system into the role of the family. Alluded to earlier, the additional priority of looking at complaints. I think it falls more reasonably under the Queensland system into the role of the Family and Child Commission, and I know that the Family and Child Commission has plans to engage with the Aboriginal and Torres Strait Islander communities, and indeed there's a commissioner position within the Family and Child Commission which is specifically related to Aboriginal and Torres Strait Islander communities.
Ms. Glass?
Similarly, children and young people in place in Victoria who I understand does good work in this area.
So you would expect him to work in the area that Mr. Kinman's just described his agency as done?
That's essentially the role of the Commission in any event. I mean, my office does not have a specific function in dealing with out-of-home care.
Thank you. Now, Mr. Kinman, as you know, kinship placements occur in New South Wales where it's considered appropriate for the child to be placed. There's been some evidence about firstly, the nature of the assessment of kinship carers, and secondly, and probably more relevant to you, is the support that kinship carers receive and the consequences of that for the safety of children in their care. Now, is that a matter that's come to your attention?
It has, and this, I think, reflects the benefit of a wide range of functions complementing each other in terms of being able to put the focus on issues in terms of vulnerable members of the community. So, for example, in the in-care review area, we looked at the level of casework support provided by community services in terms of out-of-home care placements, and we reported that, for example, in some cases, 80% of out-of-home care placements were not receiving casework support. And of course, that
sorry, what percentage did you say?
About 80% of cases weren't receiving any casework support. So that kind of information fed into the Wood Special Commission inquiry and formed part of a broader evidence base the transfer of children from government care to the non-government sector. But one of the things that we noticed from our in-care review work was particularly poor levels of support provided in the kinship care space.
Support by those agencies responsible for placing the child there.
That's right, and poor levels of caseworker monitoring, and our concerns were heightened by the fact that our review of quite a number of those placements indicated that they were quite high-risk cases.
What did you do with that information?
We completed a report, put the spotlight on that issue, as along with the issue, of course, of the poor casework supervision generally, and that information, of course, was fed into the Wood Special Commission of Inquiry, and along with the evidence of others, helped to inform the government accepting the recommendations of Justice Wood that the out-of-home care sector, that the children should be transferred from the government out-of-home care sector to the non-government sector.
Now, children who have been subject to a criminal act would have in New South Wales a prima facie entitlement to compensation under the Victims' Compensation Scheme. Now, did you look at that?
Yes, once again through our in-care review work, we came across a number of children who, many of whom were eligible for victims' compensation as a result of the circumstances that gave rise to them coming into care. But there are also cases that we saw where children had been abused in care. And so in reviewing the files of those children, we're interested to see whether victims' compensation claims had been submitted. From the in-care reviews, we could not see good practice in that regard, so that led to a broader investigation where I looked at a fairly large cohort where there was prima facie evidence to indicate that the child was eligible for victims' compensation, and the investigation clearly showed very poor practice.
And you reported on that as well?
We reported on it, and that led to substantial work by the department in terms of improving its practices. So they invested significant resources in seeking to identify children eligible and in terms of progressing their victims' compensation claims. And of course, this is essential in terms of children's rights and their right to redress. Some recent work that we've done in this area would indicate that whilst there have been improvements, and it is important for me to stress that there have been improvements, we're still having children who are eligible for victims' compensation who are leaving care without their application having been adequately progressed.
Thank you. Now, you've indicated that you have the power, as do the other ombudsmen, to initiate investigations. Do you have any current investigations underway in relation to out-of-home care?
Can I take that on notice?
Certainly. Can you tell us a recent investigation you've done that's affected the protection of children in out-of-home care?
There's a matter within only a couple of weeks ago that I completed, and it looked at the whole issue of, in detail, critical information assessment, critical information exchange in a whole range of contexts, including, for example, information assessment in relation to carer assessments, information exchange by community services with non-government agencies who are conducting carer assessments using Chapter 16A, the issue which I've referred to earlier of information exchange with the police where there's allegation of criminality. So within the context of that report, we outlined the fact that for quite a number of years there have been a range of issues pertaining to information exchange which go to the safety of children, and that further progress is needed in relation to improving practice in connection with a number of those areas.
Chapter 16A was introduced into your legislation as a result of Justice Wood's recommendation in 2008, and it was designed, according to his report, to significantly improve the exchange of information between relevant agencies in order to better protect children. Has it achieved that?
I think it's been a big game changer. A big game changer.
So is it the case that what is now needed is a cultural change in relation to the willingness to, rather than any legal impediment?
16A is a wonderful provision. We had put on the table, I think as early as about 2003, 2004, the need for a revision of that type, and we are very grateful for His Honour's recommendations. And so it has been of enormous value in terms of facilitating information, and I'm confident, absolutely confident, that there have been major changes in practice. For example, we were able to reach an agreement with the police concerning standard operating procedures, which the Police Commission signed on. Now, at the heart of those standard operating procedures is the acceptance that New South Wales Police is able to exchange information to bodies that are dealing with reportable conduct matters, to assist those agencies to know what the current risks are and for them to be apprised of ongoing developments in relation to the investigation, and at the end of the investigation to be apprised of relevant evidence.
What's the situation with the exchange of information between states about children in care and the protection of those children? So exchanging information for the purpose of protecting children in care. What are the impediments to that? We've
looked at a number of matters where their information ought to have been exchanged and it wasn't. The good thing about 16A is that it sends a very clear message that this is the way business should be done. So often the argument is put, the good thing about 16A is that it sends a very clear message that this is the way business should be to facilitate the exchange of the information. Now, I'm not sure that that should be the benchmark. I think what's incumbent on us as a community is to determine what ought to be exchanged and to have some legislation which promotes the exchange of information across borders.
Just turning back to interstate exchange of information, if Mr Clark rang you and wanted to know about turning back to interstate exchange of information, if Mr Clark rang you, Queensland, and was the subject of a complaint that he was aware of, whether you had any information about that person, could you tell him?
The process that I would use in those circumstances would be to use, would be to use the police. So if I had some information, for example, suggesting potential criminality, my starting point would be, first of all, I'd look on, I'd make sure I had complete holdings. I would then, in those circumstances, if it's potential criminal behaviour in place, I would be picking up the telephone and having a discussion to a senior person within the child abuse squad and indicating to them if I felt that it fell under a legitimate law enforcement exemption in terms of information exchange, I would be on the phone and indicate, look, I think for a legitimate law enforcement purpose, and of course that can be read quite broadly and should be in my opinion, information may need to be provided to a particular police counterpart in Queensland, with a view then, if that individual felt that that was information that Mr Clark needed to have, to provide that information. Now, you see, I would claim some expertise in this area. But can you imagine, for example, if you're a practitioner and you might be a chief executive, but you're not particularly familiar with the legislative provisions nor do you actually have the level of contacts that I have.
I understand, Mr. Kinman, you're saying that there should be a simpler system that doesn't require inside knowledge.
Yes, and sometimes, for example, no matter whether one knows the tricks of the trade or not, there isn't an opening. Can I give you an illustration?
For the moment, let me leave your illustration and turn, if I can, to Ms. Glass. Are you satisfied within your jurisdiction that you could obtain information relevant to the protection of a child in out-of-home care from a child-related agency in Victoria?
I could obtain that information if I knew what to ask. I think the issue in my jurisdiction is that I don't get to the complaints, I don't get to the allegations, and without that, you don't have the raw material upon which to investigate.
Leaving aside how you obtained the information, but if there was information available to you that meant that you, to exercise one of your functions, needed to access information held elsewhere in the state bureaucracy, do you believe that the position in Victoria means that you would be able to get that?
Yes, I do.
What about exchange of information with interstate colleagues?
I have particularly stringent confidentiality provisions in my Act. I think they're too stringent, and I have already made this point to government. But I do have some gateways in relation to my fellow parliamentary colleagues. I have to look rather more closely at what those gateways are.
I'm sorry, when you say parliamentary colleagues...
Other state ombudsmen.
Yes, thank you. Mr Clark?
It's worth me making it clear I have no operational responsibility for police in Queensland. So any operational matter of police I'm not entitled, specifically not entitled under my Act, to inquire about or into. So that does create, I think, some significant limitations. If it was with any other public sector agency in Queensland, the Department, the Public Guardian, and the like, and as I said, through Section 10C of my Act, an external body, potentially, I do think my powers are quite significant in terms of obtaining that information, to the extent that legal privilege also doesn't apply to that information. So a department cannot seek to withhold it from me on the basis of legal privilege. They can't do that either.
Have you had experience interstate seeking to give or obtain information relevant to the protection of a child?
I can't recall anything, no.
What about give or exchange information relevant to your other functions?
But with my interstate colleagues?
With other interstate agencies?
With other interstate agencies. There's nothing, there's no matter that I recall at the moment. The nearest thing, which is not particularly near, would be in regard to transport regulation for heavy vehicles, for example.
No, that is somewhat distant from our concerns.
It is.
Thank you. Now, Mr Kinman, the Royal Commission heard evidence from Ms Boland yesterday about the establishment of a carers register. Does your organisation have any role in relation to the operation of that, leaving aside its establishment?
Yes, we do. Well, first of all, matters that involve that aren't sustained, but where there is some evidence of concern, are matters that will be kept on the register, first of all. Secondly, if we hold information of significant concerns in relation to an individual, and we might be concerned that they might move from a particular agency, or even if we're not concerned, even if it's a possibility that they could move from one agency, a care agency, with a problematic history and then move to another, then we can put on the system a flag. And so that when the person then seeks to be approved by another agency and they go onto the care register, they will note that there is a flag on the system, and that that will indicate to them that they need to contact ourselves. In addition, there will be a small number of matters where the openness and transparency of the carer register might present a problem. And those types of matters might be cases where there is a sensitive police operation in play. And therefore, the dissemination of any information to an agency that's considering somebody to be a carer might prejudice the police inquiries. And so therefore in those cases as well, we have the option, because we do have access to the police system, we will know those cases where there are covert inquiries in play, or we'll know many of those. And therefore we do have the option in those circumstances of putting a flag on the system, which will mean the agency that's considering somebody to be a carer will not have access to information. They'll know to contact us, and then we will then liaise with the police and the individual agency on the question of what information, if any, should be disseminated.
I think the relevant agencies who select and use carers have some months before they have to put all of their information on the system. Is that right?
That's correct.
And are you responsible for putting any material on the system independently of a carer that's already there?
No, I think I hope it works. The principle is the flag is all that's needed. And so that lets them know that they need to make contact with us, and it's at that stage that relevant information, depending on the circumstances, we can assess what information needs to be provided. Relevant information will be provided.
Now, a key issue for the Royal Commission is disclosure of allegations by children or by adults about abuse when they were children. There has been a deal of evidence about and from young people who say why they don't disclose, and commonly the evidence is that they won't be believed. They might otherwise like the placement and will be moved from the placement, and they don't want to upset the apple cart. You've done some work in that area, haven't you?
We haven't done a great deal of extensive work in this area, and I've got to say it's an area where we ought to do some substantial work. But we have looked at a snapshot of matters, for example, 23 matters, quick snapshot of matters finalised involving 46 children where sexual offence was the primary reported allegation. And I don't think this will come as a surprise to anyone. The analysis revealed that the alleged victims predominantly disclosed to subsequent carers after they'd allegedly, after the allegedly abusive relationship placement had finished, and that was in relation to the 46 children. That was in 8 cases. Biological parents in 7 cases, caseworkers in 5 cases, other professionals such as psychologists or teachers in 8 cases, and then you had a sprinkling of other matters to a friend or a peer, disclosures made by another child. I think that supports the evidence that's been provided to this commission at various points in time, that in terms of natural safeguards for kids, we really do need to look to ensure that there are a range of opportunities for children in terms of making disclosures, and that, yes, good casework supervision is important, but children having individuals who they trust, whether it be a caseworker or somebody within the community, is absolutely vital. I mean, the idea of a child being abused and not having anyone to talk to about it is a terrible thought. And so, and of course, for good reasons, children don't often, will very often not talk to the person who's providing the care. They'll need other individuals, or there'll be other individuals with whom they'll share their private thoughts. And so, from a child-centric perspective, the child not only belonging in the carer situation, but really belonging in the community and having people who they trust is absolutely vital.
Thank you. Ms Glass, the Royal Commission is also interested in complaint handling systems in the area, the subject of its terms of reference. Has any work been done by your predecessor or by you in relation to determining best practice in complaint handling processes?
We've done quite a lot of work in best practice and complaint handling processes, but I think in this particular context, I look very much to the New South Wales model and what they've been able to do there is marry up the complaints handling with the mandatory reporting, which is something that other ombudsman's offices don't have. And I think that gives a richness to the data that we lack.
What would your view be of there being a nationally consistent approach to handling of complaints in, again, the area, the subject of this Royal Commission?
I think that always sounds very attractive, and in principle it is attractive. I think there's always a danger with nationally consistent approaches that it becomes the lowest common denominator rather than the best practice. So yes, in principle, but when you look at the range of approaches across states, one of the things that you will already have seen from this morning is that we have an Ombudsman's Office, and I'm very admiring of the work of my New South Wales colleagues, that has a very specific statutory function in this area that is very specifically resourced, and that allows them to do things that other offices don't do. So it's a package. It's the sort of thing that, in principle, I think is very worthy of exploring. I think these are important initiatives. And I think it is a very good solution in New South Wales. It's potentially a good solution everywhere. But it's not about simply giving the function to an ombudsman's office or giving the function to a particular agency. It is that whole package of activity that sits with it that is important.
Mr. Clark?
I think Deborah's comments are very, very appropriate. I think the distinct difference between the broad ombudsman jurisdiction and that which exists in New South Wales is that the specific legislative, not only opportunity but obligation to do that work and the specific resources associated with doing that are really critical to being successful in the complaints management process and the linkages to other aspects of the system, whether that be mandatory reporting, schemes or other aspects in the complaints management process and the linkages to other aspects of the system, whether that be mandatory reporting, the resourcing and potentially additional legislative provisions. There is always the risk that it will be simply overtaken by the huge volume of other work that ombudsman officers in general deal with.
Mr. Kinman, is there anything you wish to say about national consistency in relation to complaint handling?
In the disability area, the Victorian Disability Commissioner has developed, with a firm by the name of ARIMA, a very good tool.
Is that ORIMA?
Yes, and it's a disability complaints tool. We, instead of doing our own thing, my view is that if I see something good, I'll grab it. And so we had a look at the complaints tool, and we then spoke to Ageing, Disability and Home Care about it, and they embraced the idea, and there is now available to all disability service providers in New South Wales the ARIMA tool, and at very low cost. Now, there is no reason, and my hope would be in terms of that particular tool, that with the National Disability Insurance Scheme, that tool or a variation on it could be used as the platform for a national complaints tool. It seems to me that there's no reason why we couldn't have both an IT system and policies and procedures that enunciate best practice and best practice in relation to reaching out to kids under a national complaints tool. Let me also say we're doing work with ARIMA in connection with our reportable disability incident function, both and also in relation to our reportable conduct function. So we're hoping that perhaps other states and territories might adopt the New South Wales system, and in anticipation of that, what we want to do is to make available, in terms of reportable disability incidents and reportable conduct matters, an IT tool that would deliver national consistency. Now, there's no good reason why that can't be delivered.
Thank you, Mr. Kinman. I have nothing further on.
Thanks, Ms. Furness. Mr. Kinman, can I start with you. With respect to the nature of the investigations that your office is conducting, have we understood correctly that that the first thing that happens is that some sort of definition is applied to the nature of the complaint, so that you're making an assessment about whether or not what you're receiving is in fact a matter that must be referred straight away to the police?
Yes, absolutely.
And who's responsible for that decision?
Within my organisation, it will go to generally these matters with the principal investigator, and we have within my organisation, it will go to generally that they will ensure that one of the early issues that's considered is there prima facie evidence of criminal behaviour. And what's important to bear in mind there is that you might not have, in terms of the particulars of the allegations, an allegation of a criminal offence, but you might have information that gives one reasonable cause to suspect that you might have criminal behaviour in play. One is likely to reach that conclusion too if one has looked at the police system and noted that a range of disturbing behaviour on the police system in connection with that individual across time. And obviously what we also look at is the child protection system. And if one has disturbing information on that system as well or on its own, which might be indicative of criminal behaviour, then we will pull together a brief. And whether it's a local area command or the child abuse squad, we'll then make a telephone call, we'll explain the circumstances, and we'll then send the information across to the police. In some cases, it's not just sending information to the police, it also involves a call to Family and Community Services. I have contact from time to time with the Deputy Secretary, and I've always found her more than willing to take my call on those matters and more than willing to assist.
So you're not identifying at the moment any gaps or shortfalls in that process?
I'm extremely encouraged by the level of cooperation that we receive.
And similarly, with respect to the cooperation with the police, both with respect to the provision of information to you for the purposes of your investigation, and then in the wake of any police investigation that falls short of a criminal prosecution, do you identify any shortfalls or problems in that area?
I know that there's a perception that ombudsman's officers are in the business of criticism, but I would be giving inaccurate evidence if I indicated that I had any concerns. I have to say I'm impressed with the response of New South Wales Police to the calls that we make, and I'd be happy to provide evidence in support of that.
We have heard, and it was intimated in some of the questions that Ms Furness put, that sometimes issues around privacy and confidentiality will work as barriers to the successful progress of an investigation or indeed an entire system. You're obviously not identifying that as a problem.
That's correct, Your Honour.
Are you aware as to whether or not incomparable systems across state and territory borders that those problems do exist for those agencies?
I'm not. I don't have detailed familiarity with the provisions in each of the jurisdictions, but I'm reasonably confident that Chapter 16A of the Children and Young Persons Care and Protection Act is a model piece of legislation which makes the decision concerning whether one is entitled to exchange information very easy, and because of the broad range of agencies that are able under that legislation to exchange information, we simply don't have a problem in relation to intra-state information. But cross-border information is another issue.
It's more complex. Thank you. Can I ask you a question that's been touched upon about the carers register? We've heard evidence about it being quite obviously a new initiative. In the area of allegations of child-on-child abuse in a care environment, so an allegation that's not being directed at the carer. I probably should have asked this question if Ms Boland and didn't, but would the carers register pick up that child-on-child allegation to the best of your knowledge?
To the best of my knowledge, no, unless, for example, there was an indication that the relevant carer had failed in connection with a child-on-child abuse matter.
And who would be making that assessment?
If, for example, the matter was reported as a neglect matter to my organisation, and I think I gave evidence earlier concerning the significant number of reports of neglect, then that decision would be made by the agency with responsibility for investigating the alleged neglect under our oversight. And I think the earlier evidence I gave was that for neglect matters that are notified to us that typically involve an alleged failure by a carer to provide an adequate response to safety risks to a child, about 42% of those during the period that I quoted earlier lead to sustained findings. So that would be relevant information that should be on the care register.
Thank you. And you also gave evidence with respect to, in answer to a question from Ms Furness about the shortfalls in the referral of matters to the police inside the Child Protection Authority in New South Wales. So you touched upon that. I just want to come back to that with you to ask you to elaborate on that, please, for us.
There have been a number of occasions where community services has information that indicates potential criminality, and there has been a failure to notify the matter to the police. More recently, they've issued FACS, Family and Community Services, has issued guidelines to indicate that where there is a serious violent offence, then there ought to be a referral to the police. One would think that makes sense.
So can I just interrupt for a moment? Specifically in the area that we're looking at, in the out-of-home care area, and the sexual abuse of children in the out-of-home care area, are you saying that your agency has uncovered circumstances where referrals that should have been made to the police have not been made?
My understanding is yes, in the out-of-home care area, certainly in relation to, is my understanding, and certainly in the reportable conduct area, we would be happy to provide evidence in support of that claim.
Thank you. And again, just to clarify, you're talking now in terms of recent years?
Yes, we are talking about recent years, and I would have to say that I think there's been some progress made in this area, but I'm not at all confident that we've got best practice in play.
And how have those matters come to the attention of your office?
Well, they've come either via the reportable conduct scheme. Sometimes they may have come from complaints, or we might have contact with a stakeholder who's brought concerns to our attention. And as a result of us then having a look at both the police system and the child protection system, we're then very well placed to form an assessment as to whether the information ought to have been sent to the police. One of the difficulties in this area, of course, is that sometimes people tend to write policies in terms of whether one believes that there's been a serious indictable offence. Well, how would one know whether one can believe whether such an offence has been committed without there having been adequate inquiries? And so there needs to be a very clear understanding that where there is criminal behaviour and there are associated child protection risks, there is no good reason for that not to be referred to New South Wales Police.
Thank you. Mr Clark, in the course of you answering questions from Ms Furness, you made reference to developments in complaint handling processes inside your agency in the last 12 months. And I understood your evidence to be that you're working on improving and developing complaint handling processes. That's correct, is it?
Yes, Your Honour.
So one assumes that shortfalls have been identified. Is that correct?
Not so much shortfalls, but opportunities, I guess is the way I would say it, because, and the reason I choose to use different language is that, for example, of the matters that I alluded to earlier, where we did a very cursory analysis in the last couple of days, there are, I don't believe, in regard to the terms of the matters of concern to this Commission, any complaints from a child. They all come from adults. So whether, in fact, our system actually is reasonably accessible to children is one of the matters I would like to investigate.
Yes, I was going to ask you about that. In fact, yes. both you and Ms Glass about that.
Yes, and I think there's opportunities for us to do that much better. We have officers from my office have participated with the department in the recent working parties that have looked at child-friendly complaints management system in the department, and I think there are lessons for us from that process which I'm eager to consider and apply if we can make it work.
All right, so there is work being done in your agency in that area?
There will be work done this year. It'll be part of my review of what happened in the last 12 months and my comment before about including my office in that review.
And Mr Clark, are you specifically looking anywhere, either inside the borders of Australia or in other international places, for assistance and guidance?
At this stage, I haven't set a scope to the review other than that it will be specifically include agencies within my jurisdiction. So notably that will be the Department and the Public Guardian's Office in Queensland. My own office. Beyond that, I haven't set a scope and I haven't done the research that's necessary to underpin that review, but it will be something for the near future.
Thank you. Ms Glass, I was going to ask you to talk to us about exactly the same issue.
Accessibility to the complaint system is a major piece of work in my office. I'm not comfortable with the level of knowledge within the state of Victoria about the Ombudsman's services and what my office can do for them. And I think the numbers bear that out. So it's already something that I'm looking at. The accessibility of children to the complaint system, I think, is an important part of that. It's not the only part of that. But there is a broad theme for me about vulnerability. And I'm looking at the access of my office to people who are vulnerable. And that clearly includes children and includes children out of home care. It's a major piece of work. It's got numbers of elements, including developing a single complaints portal across the public sector in Victoria, working with third-party advocates. And it's something that I think we're going to be developing for some considerable time to come. It's part of a sort of broad 10-year vision I have for, in coming into the role. I don't think this is one I'm going to be able to solve very quickly.
Mm. And you gave evidence to us about the piece of work that your office has recently done in the disability area and the report that you've tabled. And I understood your evidence to be that one of the recommendations that came out of that report was a recommendation to have one oversight agency in the disability area.
Yes.
The rationale behind that recommendation?
The system is much too fragmented. And what we found with that, looking at the different elements of the system, is that it has gaps and it has overlaps on the boundaries. And the problem with that is that nobody owns the problem. Nobody takes responsibility. Nobody gives leadership to that. And what we found is that there are a lot of well-meaning players in the system who have something to say, but no real responsibility for fixing it. Mm. So you need that single oversight body to actually carry that responsibility. And if you can marry that with features such as mandatory reporting, and we've looked very much at the New South Wales model for that, then you can actually bring the powers, the functions, the information together in a way that will make a real difference.
Did you, I assume you consulted with relevant agencies about the development of that recommendation and whether or not it would create problems or issues for those agencies?
Well, it actually was a recommendation that I made, if you like, in principle, because a real issue, of course, is the introduction of the National Disability Insurance Scheme. And I was very mindful, and I included in that report, that has to be a factor. If we didn't have the NDIS, coming ahead in some years' time, then it would have been a much broader recommendation for systemic reform within the state. Clearly, we're looking at a national system. We don't know what the safeguards in that system are going to look like. So it was a principle for me about saying these are the elements of safeguarding that need to exist in Victoria, which includes strengthening our existing systems to ensure that when there is a transfer of responsibility to the Commonwealth, that we sign up to safeguarding arrangements that are no less than the ones we have in place or need to have in place at present.
Thank you. Commissioner Fitzgerald.
Just one question. It goes to historic abuse. Given we have you here, one of the issues that's arisen in the Commission's inquiries more generally has been about the way in which past residents of out-of-home care, and that might actually be recent leavers, have had difficulties dealing with government and non-government agencies in relation to their complaints about abuse whilst they were in care. Very few of the people who have come to us have ever said that they've taken the matter to the Ombudsman. But I just want to talk in Queensland and Victoria, are they matters that have come to your attention where people are not complaining about their current circumstance in care, but their previous circumstance in care, and have found their dealings with either government departments in the case of Queensland and Victoria unsatisfactory?
It's certainly possible we have had some complaints of that nature. I can't answer that question directly, I'm afraid, because I'm not aware of any individual instances. But it wouldn't surprise me to hear that. And it certainly wouldn't surprise me that people on the whole do not feel confident about taking complaints to the Ombudsman, or they don't know that the Ombudsman can actually assist them in these circumstances. And that's not just a problem in this area, that's a much broader problem about lack of understanding of Ombudsman services.
Commissioner, I cannot recall any matters. Certainly the analysis in the last few days of last year's complaints, I did not see anything that related to historic abuse. But like my Victorian colleague, there may well be examples in the files which, if we searched, we could find.
The second thing is, if I could just take the issue about the reportable conduct, both Mr Clark and Ms Glass, you've indicated that you support a reportable conduct regime of some description. That regime's now been in place for well over a decade. All states other than New South Wales have failed to introduce a reportable conduct regime of the nature that we've talked about. Listening to Mr Kinman, are there anything that he has said that jumps out of you as an impediment to the implementation of a reportable conduct regime in your jurisdictions? because the concept and the practice has been well known for a very long time. So is there anything that has been said that jumps out at you that would pose an impediment, realising that you do not set policy for government?
Well, if I could just respond by saying there is mandatory reporting in Victoria and has been for some time. The reporting is to the department. It's not to my office, it's not to an independent agency, and it's not on the same basis as exists in New South Wales. I don't think that there is any impediment other than resources and political will.
In my case, Commissioner, I think my current jurisdiction would not allow me to deal with the police, would be a significant impediment to the way that the system operates in New South Wales. With other agencies, less of a problem. The information sharing arrangements in my own act would probably need some attention because there are very limited provisions under which I can share information with another body. I can get information from other bodies with impunity pretty much, but I can't give it back, and that would be an issue that we would have to deal with.
If I could add, I do have a similar set of problems around information sharing and indeed the police jurisdiction, but none of these are ones that can't be solved.
No, it goes without saying that legislative changes are absolutely required if you're going to introduce that regime. But thank you for that.
Ms Furness, anything arising out of any of that for you?
Nothing further.
All right. Thank you very much to the panel this morning. Thank you for your attendance and cooperation with us, and you're otherwise excused, and we'll have a new panel at 2.
We will,
Ms Furness, thank you.
That will be the last panel for the hearing.
Thank you.
All stand.